on behalf of the American Australian Association, I'd like to welcome you to this immigration update. I'm Louisa Teo, and I'm based here in Cambridge, Massachusetts. I'm delighted that we've got people joining us from Acapulco, from Adelaide, from Aspen, Bethesda, Barangaroo, and Brooklyn. And, you know, when we first started doing these, it was like an acoustic session in a small pub. But tonight we've got so many people who have registered to join us. It's like stadium seating now. And one thing that indicates to me is that there are a lot of people in the same situation. But there's no one who I'd be more delighted to have an update from on these matters than Chantal, who's joining us again. Welcome back. There couldn't be a more delightful messenger, even if not all of it is good news. And so I think we'll get right into it. What do you think, Chantal? Do you want to start the slides?
Thanks, Louisa. I noticed that all these people come from A places and B places. We didn't get to any. So hopefully there's people from other places too. And way to make me nervous. Now, apparently we're not just in the, small set in the pub. We're in a grand stadium. Holy moly. But it's my pleasure to be here again. And thank you for having me again. All right, so let me, I know we do the same usual thing. I think people, I've asked people, do you like the slides? Do you not like the slides? And a lot of people have said the slides have been really useful to them and they've been able to use them thereafter. So we've kept with this format. So I'm going to share my screen right here.
And I want to say that we got hundreds, probably between 200 to 300 questions from everybody who's joining us now. So thank you for everyone for participating. We had, this is a series, and so these questions that came in. So relating to furlough and unpaid leave, the first two bullet points, as well as long dated I-94s and filing an additional LCA, I want to let you know that we did cover those in depth already, and to either go to Chantal's website or the American Australian Association website and look under webinar replays, because we won't be touching on those again tonight. We have also covered in depth RFEs, green card holders outside of the US, and E3 premium processing. But for those three bullet points, I would encourage you to stay on because we do have updates on those.
Yeah.
So I'm going to hand back to Chantal and she'll take us through what we're discussing today.
Thanks, Louisa. That furlough and unpaid leave made it back on to the reminders because someone did have a question saying that they wanted to be able to take unpaid leave on their E3. So we stuck that back on there, which is good. So tonight, you said we got over 300 questions, and we did. We got so many. And the main areas of questions were around, I'm vaccinated, do I still have to quarantine in Australia? Can I get out of testing requirements? Do I not have to quarantine when I get back? Can I travel to Europe this summer and I'm not subject to these other proclamations because now I'm vaccinated? So there were a lot of questions around that. We had a lot of questions again about the green card. So we're going to go to cover that, and about E3s and where to process them right now. So we're going to cover that. And then I threw in some things in there that I thought were important for people to know that I've taken notice of over the last couple of months since we last met and did the webinar. One of them was with social media. Now that USCIS is asking on the DS-160 for people to list their social media handles. I just wanted to touch on that tonight. The end of presidential proclamation, which applied to people not being able to get issued and enter the US on their first time Ls, H1Bs, J1s. Someone asked that particular question in relation to an L. They said, when can I get an L visa issued in Australia? So now is the answer to that. Since March 31st, you can. And we're going to go through that this evening. National interest exemption. So this is that proclamation that bars entry to the United States from Schengen, UK, Ireland, Brazil, Iran, China, South Africa, and now as of today, India has been added to that list. So going to touch on that and what that means, and what that means in relation to people that are vaccinated as well, because we get that question, and what if you have a visa and are still subject to it. Green card holders outside the US and the E3s, as I mentioned. So we're going to go through all those. So let's jump right in with respect to all the questions around vaccinations. It's really hard to follow, and people are having difficulty understanding what applies to them and what doesn't, because they're going to the CDC website, but then there are the states that have their own rules. So let's just and the CDC website says, you don't have to do this, but you should do that. And you don't have to do this, but you should do that. And you can do this, but you don't have to do that. It's kind of like when that, the beginning of COVID, when there was a woman that did a skit about, you can go outside, but you shouldn't, but you should stay inside, and you should wear a mask, but masks aren't useful. But you should do this and you shouldn't do that. And, it's kind of like that, what these rules about what people that are vaccinated and not vaccinated can and can't do. But I'm going to try and simplify it. So CDC, basically the only requirement that CDC has at the end of it is that you need to get a test, a COVID test, 3 days before entry to the United States from international travel. I want to jump back because I'm seeing the slide that's in front of me is all about vaccine and what does it mean to be fully vaccinated. So just want to go through the definition of that. Fully vaccinated is someone who has had their 2 weeks post their second shot of the Pfizer or Moderna vaccine, or their 2 weeks post the single shot vaccine of Johnson & Johnson. So one thing that, I know everyone was looking forward to, which is, do I not now have to quarantine, and do I not have to test and so forth? You're not exempt. You still need to look at the state rules and each country's guidelines with respect to that country's conditions, whether you're vaccinated or not. So pointing to Australia, which is the question, the country that we had most questions on, which is the 14-day mandatory quarantine. If you're fully vaccinated, you still have to do the mandatory 14-day quarantine right now. So I'm sorry to report that news, that even if you're fully vaccinated, you still do have to do that 14-day quarantine going back to Australia. Also, the other question we got was, when people have been in Australia for more than 12 months, they need to apply for an exemption to come to leave Australia. So the rule is, if in the last 24 months you've been more in Australia than out of Australia, in other words, if you've been in Australia more than 12 months in the last 24 months, then you need to get an exemption. So this still applies even if you're fully vaccinated, because I've had that question a lot too. I'm fully vaccinated. Can I just leave Australia? No, you still have to get the exemption. When is the other question is, when's it going to end? When's the quarantine in Australia going to end? When will Australia let people out? I wish I could answer that with a definitive answer. I don't have a definitive answer to that. I think what we're seeing some things open up with respect to quarantine and travel now here in the US, but I think that's because, and where it has opened up, what they've stated is, now that people are vaccinated, they can travel at less risk to themselves, is the wording. And I think that when we're going to see people able to go back to Australia and not quarantine is when more Australians in Australia are vaccinated. And so there was a bit of a delay in the rollout of the vaccine in Australia with the issues with the AstraZeneca vaccine, with the blood clotting and so forth, that I think Australia's timeline of what they initially anticipated the vaccine to roll out has now been delayed. So I think we're probably still going to see this quarantine through to the end of the year. I don't see it letting up before the end of the year. And I know a lot of people are hoping to go home for Christmas, but I don't know if you won't have to do quarantine then. But we'll keep an eye on it. And of course, definitely if anything changes, we'll absolutely do an update, Louisa. So that's the update on that. So what about in the US? What are the guidelines now with respect to if you're vaccinated or not vaccinated and quarantine and getting tested? So the long and short of it is that from the CDC rules, you need to, if you're coming in from international travel, then you must have a negative COVID test that was taken within 3 days of departure, or evidence that you had a positive COVID test and that you've recovered in the form of a letter from a doctor or electronic evidence of that. The rest of the guidelines with respect to interstate travel and international travel, whether you're vaccinated or unvaccinated, are all shoulds. Like, you really don't, no one has to do anything if you look at it. So if you're vaccinated, you don't have to test before you travel interstate. you don't have to quarantine unless the state or where you're going requires it. So again, it's pointing to look at the state's rules, look at where you're going's rules. Returning from international travel, it says you should test 3 to 5 days after international travel if you're vaccinated. And again, even if you're unvaccinated, they're saying you should test 3 to 5 days after arrival, and you should quarantine for 7 days if you get the test 3 to 5 days after arrival, or 10 days if you don't get the test after arrival. But no one's mandating it anymore. So you really do have to look at where you're going and which state you're going to. I made a note down there that some states, and not only the state you're going to, but the city that you're going to, because it can differ. So for one example, and some states can have, can impose that it is some states have said that it's a misdemeanor, a level C misdemeanor, and have imposed fines for not sticking to quarantine requirements. So for example, I have here what I printed out with Illinois, there is no statewide quarantine orders. However, in Chicago, and I'm saying Chicago because I know we do actually get a lot of listeners from Chicago that follow up after with questions. So this goes out to the Chicago crew. Chicago has its own 10-day quarantine mandate for anyone arriving from any of the high-risk states. Visitors to those states can offer proof of a negative COVID test taken within 72 hours of arrival as an alternative to quarantine. And the only exemption that it allows is for people who have been fully vaccinated at least 2 weeks prior to arrival. And then it lists its penalties as violators in Chicago are subject to fines between $100 and $500 per day, up to $7,000. So just the point I'm making is just check where you're going and the state rules, because that's what is currently being followed. So so the one common rule across the board is for international travelers coming in, whether you have been vaccinated or not, doesn't matter. So you can't get around if you're coming to the US from international travel, because we've had people say, well, I've been vaccinated. Can't I just show proof that I've been vaccinated and not have to get a negative COVID-19 test? No, you still have to show evidence of a negative COVID test that was taken within 3 days of departure, or evidence of recovery from COVID-19 infection if you had a positive COVID and a letter from a doctor. So doesn't matter if you're vaccinated, you still need to do that test coming into the US. Just to give an example of the difference in states. So New York, because I know we have a lot of listeners from New York, I'm going to do New York and LA. So New York, I've bolded here where it differs from CDC guidelines. New York changed their rules on April 10th. So previous to April 10th, there was a mandatory 7-day quarantine, and you could test out of it on day 4. If you on day 4 got a negative COVID test, you could then test out. Now, as of April 10th, there's really no quarantine requirement, whether you're vaccinated or not. No one's making you quarantine. If you're unvaccinated, they're saying, well, you should test 3 days after arrival in New York, whether you're vaccinated or not. And if you're unvaccinated, you should consider 7 or 10-day quarantine, 7 days if you test and 10 days if you don't test. You should consider it, but they're not mandating it the way they were. The other thing that New York does require, though, is that you fill out a New York State Department of Health traveler form. So that's required by everyone, vaccinated, unvaccinated, interstate or international travel. It's a pretty straightforward form. It used to be, and I'm not sure if the form has been updated after April 10th. I did travel internationally entering the US just right before April 10th, and they required a phone number or email address to be able to contact you at that point to check that you were doing quarantine. And typically the way it would work was that you would get a text message and you'd have to reply, Y or C or whatever it was to say that you're abiding by the rules. I'm not sure that now that there's no quarantine requirement if they still require your phone number or not on that when you enter. but it's just, people need to know that they do need to fill out this form, and they will be expected to fill out this form if they haven't filled it out prior or on the flight when they land in New York. Okay, so what about LA? To give you an example of a difference, in LA, there's no quarantine requirement if you're fully vaccinated. If you're unvaccinated, however, there is a 7-day quarantine required. So this is really important. So if you don't do a test after 3 to 5 days of arrival in California, then you're expected to quarantine for 10 days. So, but there's at least a minimum, if you're not vaccinated, of a 7-day quarantine there. There is a way to get out of that 7-day quarantine if you're going there for work and your work is considered to be required for the critical infrastructure sectors of the US. So critical health staffing, we have been able to get it for other jobs as well. So an example there, Louisa, is we had some executives for a large luxury fashion brand had to have executives come in from Italy, and they needed to do a shoot, a very big shoot with a celebrity in LA. And these executives did not have the time to do, they were not fully vaccinated. Some were vaccinated, some were not. But the ones that were not did not have the ability to quarantine 7 days before the shoot. So we looked at ways around that, and we were able to qualify the work that they were doing to be a essential work. Also, then they needed to check the production's rules. So if you are going somewhere, there might be the production or the people that you're working with might have their own policies and rules that you want to check. In this instance, also, everyone felt comfortable with that at the production because Italy has these flights that are called COVID-free flights. So they make sure that anyone getting on that flight is COVID-free, I guess, but you would hope that most flights are COVID-free these days. Okay. So that's just an example. So if anyone does need to try and get out of, if a state does have strict quarantine requirements and you absolutely can't quarantine and you think your work is essential, you could contact an immigration lawyer and see if there's a way around that. Okay. Did you
Chantal, I thought this was so fascinating. So I'm someone who's been on an F1, an E3, a green card, but that was years ago. And so I've never seen this before. When I saw that we were discussing this, I thought it was intriguing.
Yeah, apparently a few other people did too, because in their questions, there were 2 questions. Well, actually one question where they're like, social media footprint, what do you mean by this? So I guess it's like, what do you call this? But I thought it was important to bring up because it's been coming up a lot lately as we help our clients fill out their DS-160 for their visa applications, regardless of whether it's E3, O1, L1, any visa application right now that requires a DS-160. They are now asking since May last year, so just under 2 years ago, but people are now starting to already renew after, so we're at the 2-year point. So people that didn't have to do it before now have to disclose their social media handles. So we're getting a lot of people saying, oh, I didn't have to like tell them my Facebook or my Instagram last time. Why do I have to do this? So it's an indication that the immigration officers, they do Google you before you come to an interview. They do look at these social media handles to check whether you have been, what you've been doing in the US is consistent with what you've been saying you're doing in the US. Maybe you've been a student the whole time and now suddenly on your Instagram, it shows you're working, which you shouldn't be, for example. This is a way that they can check whether, firstly, whether the actions you've been doing in the US are consistent with your visa history. And secondly, to see if you might be a threat to the US government. So we encourage our clients to really not post anything on their social media that could be deemed to look like they're doing something inconsistent with what their visa allows them to do in the US, or anything that has a strong political stance, or anything that could suggest that you're opposed to the US government system or the way the government system works and so forth. So the ones I want to point out, there's a lot here that I had never even heard of, but the ones that I see the most for our clients, the obvious ones, Instagram, LinkedIn, and I'm going to spend some time on LinkedIn because this is a really big one. Instagram, what I see is where there's the posts that people, have a post of themselves. For example, they might be a bar manager, but now they've got them pictures of themselves checking out cocktails behind the counter, which they shouldn't be doing. LinkedIn is really important because I see people's dates all over the place that don't match their visa history or don't match their resume. And this can be a real issue. So if they look up your LinkedIn and nothing matches up, that's going to lead to a lot of questions. And we want to not raise any red flags. We want as little questions as possible. Let's not raise any questions when we're in a visa interview. So Instagram, LinkedIn, Pinterest is, people like my Pinterest. That's usually a harmless one because people are just putting on their hobbies. Hopefully it's a safe hobby. Twitter is the other big one. And, and YouTube, because YouTube videos, suddenly someone's like an online chef, making money as a celebrity chef on YouTube, but really they're a financial analyst on their visa. So let's just keep an eye out for that. Twitter, like you mentioned, that's something that people are often put political statements on. So just be mindful of that. We want people to be mindful of that. All right. This is where I get into the whole LinkedIn thing and where people, like what I'm seeing from this whole, now they want to see your social media. So they're asking for your LinkedIn. So now you want to make sure your LinkedIn matches up. Now, previous, I would check the website, I would check people's resume and make sure that that matches their visa history. But now I'm finding like half my job is like checking people's LinkedIn and telling them to fix that thing up. So this is an example of a client recently that I did a consult with, and all the different titles he had going on in 4 different spots. So we were like, okay, you need to clean this up. What are you? What are you? You're on your LCA, you were a brand and campaign designer. Okay. So now your LCA said that, so that's what you got to be. You got to be consistent with one thing. And since this is the thing they've seen before, this is what you want to be. So he had brand and campaign designer on his LCA. He had director of brand on the company's website. He had creative director on his LinkedIn, and on his resume, he had design director. Okay, there's an argument that all of these things kind of do the same duties, but it just doesn't look good. It's like, well, what are you? You're not consistent here. Like, what do you call yourself? What's your job? So we just want to raise those questions. So I want to just make this clear to everyone that are renewing their visas to just go back and do a big cleanup of make sure. And what you want it to match is your visa history. So when was the last time? So here, then the dates, right? So it was like he started in October 2014 on LinkedIn, but on his resume, he starts September 2014. And on the website, they said he's been there since June 2014. This sometimes will give me an indication of when they might have started, like because the E3s in 2-year increments. So I'm like, okay, well, if he consistently applied every 2 years, which is not always the case, by the way, but maybe it was around September 2014, but it could have been October because he might have renewed early, But so in that, it's what is this date? What should this date be? This date that you started with the company should be the date that you legally entered the company with a valid visa to be able to work for it. So if you have been coming in and out on meetings, sometimes people are like, well, I was kind of coming in and out on ESTA because I had meetings with the company first. So that's why I put September instead of October. Well, you weren't really authorized. Someone looking at your LinkedIn is going to think you were working there, not just coming in and out on meetings. So just the date that you first entered legally on your visa is the date you want to have as your start date.
Chantal, I'm just going to jump in with a question from Christina, which is, what if you've been promoted since submitting your LCA?
Right. This is an amazing question, Christina. Thank you so much for asking it, because this is a common thing that I see on people's LinkedIn and their resumes. Since they got their last visa, there's like 4 titles because they've been promoted 4 times. If you had a change in title and a substantive change in duties and salary, you were supposed to get a new visa to go and do this new so-called role. So if you didn't go get a new visa, then the title should remain the title that you had the last time you got a visa. and you got approved for that role and job. Now that you're going to get a new visa, great, that's at the point that you're going to be able to use the new title, because you've gone and you've gotten a new visa with the new title. So that's definitely something to be conscious of, and thank you so much for asking that question. Did you have any other questions there related to that?
No, but Christina says thank you.
Oh, great. You're welcome, Christina. We had one question from someone, I think, that said, well, what if I started like for the company from abroad in Australia and then entered a few months later? In that instance, I usually tell people to put it twice on their resume so there's no ambiguity. So put the company, the dates that you work for them, and then put the location as Australia. And then the company again, the dates that from when you entered legally with a visa, and then New York or LA or San Francisco or wherever it is that you're working in the US. So just try and make it clear so that then someone looking at it at face value, the answers are right there and they don't need to ask questions when they see that the dates don't add up or titles don't add up. We want to make it as easy as possible for immigration officers to approve the visa, right? So, and the easiest way is to raise, you know, as little red flags or no red flags. Just don't give them any questions to ask. Nothing in the documents should raise questions. Okay. What do we got next? We got the end of Presidential Proclamation 10052. Which one is that? That's the one that relates to the H-1Bs, Ls for the L person that asked that question, and Js. So this was where there was a ban from people being able to enter the US on a first time H or J and getting the visa issued. It was difficult to get the visa issued as well, to be able to enter on those. There was a carve out for the Js for a little while from October, where if their host company or umbrella organization was a member of the US Chamber of Commerce, they were able to then qualify to get in. Now everyone can, this ban has ended. So if you need your first time H-1B or L or J, you don't have to worry about chambers of commerce and so forth. You can just go book a visa appointment, get the visa and come in. So this is relatively easily to do from Australia because you can get appointments in Australia in these categories right now. If you're here and you're like, oh, I'm just going to go to London to get it, my L, that's not going to be so easy because the travel restrictions, the travel ban, the other proclamation is still in place. So getting an appointment in these categories in the countries in which the travel ban to the US is still in place is really difficult and next to impossible unless you qualify for a national interest exemption, and I'm going to get to that. So if you are in one of these categories, Australia or one of the closer countries where there's no travel restriction from are the better places to do this. So for example, we had a guy get his L in Guyana. Anyone in this instance that doesn't want to go back to Australia should stick around when I'm talking about the E3s and how to approach doing an E3 at a country outside of Australia and not in the US, because those are the same places that you'll be able to process one of these visas as well. Okay, so why is there a backlog why is it still difficult to get an appointment in these other countries that are close to the US and not as difficult in Australia? I think because since the immigrant visa ban ended, these other consulates are trying to prioritize the immigrant visa interviews. They had a backlog of 500,000, which normally is 75,000. So they're trying to get through those. They're prioritizing their own country's nationals first. So that's why there's very limited appointments for people in other countries right now. So why you're like, well, Australia is so easy. Why isn't it easy everywhere else as well? Okay. What is this national interest exemption and why am I talking about it? I'm talking about it tonight because I've had so many people say, well, I'm vaccinated. I'm going to go to Europe this year. I'm going to go, here or there. And it's not that easy to just go somewhere at the moment, especially to Europe. Not all of Europe, but the Schengen countries, which is the majority of Europe and the places where people want to go, Italy, Greece. And I've had so many people, well, Greece is letting Australians in and Americans in. So why can't I come back from there? Well, the point is that this proclamation is still in effect, that even if the country is letting you in, America's still not letting you back unless you qualify unless you're exempt, number one, from this rule, or you qualify for national interest exemption. So the people who are exempt are US citizens and green card holders. If you're married to a US citizen or green card holder, or if you have a US citizen child who's under the age of 21, or a sibling or child, or you're the sibling or child of a US citizen or green card holder, but you also have to be under 21. So I'll give an example of this. I have a client who she is Australian on an E3. Her husband is Italian on an E3D, and they wanted to go to Italy this summer. So can we go to Italy this summer? So they can get into Italy because of the rules of Italy, say an Italian national, spouses and children of Italian nationals can get into Italy. So they can get into Italy. Okay, great. Now, can they get back? So they are really lucky because they have a daughter who's just over the age of 1, and their daughter's US citizen. So this will allow them, she's their golden nugget that allows them to get back into the US. So they can go to Italy this summer and get back. If they didn't have their daughter, they wouldn't be able to go there and come back. They'd be able to go there, but they would have difficulty coming back. And to get back, the only way they'd be able to come back would be to either go to a non-restricted country for 14 days, so Mexico, Turkey, Croatia, and then into the US. And then you can't go to like Croatia or Turkey and then transit through a Schengen country to get back to the US, because then that doesn't work. So you have to come directly back. Or get granted a national interest exemption to be able to fly directly back. And these are really tough to get now. And I'm going to go through that on the next slide. So how to apply for a national interest exemption. So it was not that difficult up until March 2nd to get these NIEs approved. You could get them approved at the same time as getting a visa in your passport. In fact, we had processed between, during the pandemic and up until March, we had been able to process a number of E3s in Europe, and even in these Schengen countries, when we were able to get appointments. And the consulate at the time of processing the visa just automatically gave the person a national interest exemption to be able to fly straight back. So it was awesome. Then on March 2nd, what we saw were the rules on how to apply for a national interest exemption changed. So before March 2nd, it was, you just had to show that your role was in the economic interest of the United States, that it would benefit the US economy. Now you have to show that your role offers vital support to the critical infrastructure sectors of the United States. It's a mouthful. And the consulates are generally not approving these, like they're holding the standards really high. So for example, we have someone that contacted us that had tried to apply for one in Paris to the consulate in Paris. He is working on a $3 billion project in Malibu and was denied the NIE on that. Like you would think, and for a very, very big organization that's worldwide renowned, like the company that he was coming to do this, that he needed to come for a meeting for is a household name that people have heard. So, you're looking at that and you're like, if they're denying this guy, this is crazy. So it's tough right now. If you're going to Europe and you're not going to be able to easily come back, just think about it, think twice and talk to an immigration lawyer. The other ways that you can get an NIE is there is a way to get it through the airports before that you're going to travel back into. That is a little bit easier. It's tricky in its own right, but they're holding the standard too, that your job is still in the economic interest of the United States rather than this critical infrastructure level to approve those. So if you need one of these, I think you need to really talk to an immigration lawyer to have help with one of these. A good thing to point out is that clients that have been granted them, so for example, right now we're working on an O1 for a French national who, she said, well, I'm flying from St. Bart's, going to Paris. Her role, she's a photographer, and it's tough to claim that her role is vital support to the critical infrastructure sector. So she's considering, if the appointment doesn't get approved in Paris, flying to Mexico for 2 weeks, doing an appointment there and then entering the US. And she's like, well, I'll leave my dog in Paris and then I'll just go back. After I've got the visa, I'll go back and get my dog in Paris and come back. Well, it doesn't work. Like once you have a visa, you're still subject to this. You just can't fly back and come back. And even if you get an NIE approved, it's great for one entry to the US. And it's only valid for a 30-day period. So timing these out are really tough too, because they can take up to with the consulates, it can take up to 6 weeks to get one approved. So, you know, factoring that in, you've got to be applying for it so much earlier. You never know when they're going to approve it, and then it's only valid for 30 days. Or even with the airports, it can take as short as 5 days or as long as 25 days to get approved. So depending on when you apply for it and it gets approved, you've only got this 30-day window now for this one entry into the US. So it's just difficult. And so you can't be, it's tough if you have specific dates that you want to travel. If you can be flexible with your travel and you're happy to try this national interest exemption, then great. There are a few exceptions that we've seen open up. So as of April 8th, K visa, which is the fiance visa, that will be automatically granted an NIE to come to be with their US citizen fiance. And students, so it's opened up for students now. So any students that have an F or M will be granted an NIE to be able to come into the United States. They'll automatically be granted it if they're from Schengen area, United Kingdom and Ireland. And as of April 6th, so just last week, they said, so you couldn't come in if you were from China, Brazil, Iran, South Africa, as a student on an F1, you had to get an NIE. But now last week they said, okay, you'll be able to come in from those countries on an F if your program starts August 1 or later, and you'll be able to come in up to 30 days before. So those people after July 1, as long as their program starts after August 1, will be able to enter and be automatically granted an NIE to enter. So the funny thing about this, Louisa, is that anyone watching that's on an F1 basically would be able to travel to Europe and get back this year. But anyone who's a senior executive that needs to travel to Europe for an important business meeting and back can't. Just this is an interesting concept, right? So, and on that, we had a French national who we were considering getting an O1 for, because he has a major project, a film that's been released, that's won awards in the film circuit, and he had recently finished. He had been on an F1, so he does qualify for an O1 now as well. But we decided, you know what, it's going to be easier for you to re-enroll in school, get an F1 as a student and enter the US than try and get an O1, because it's going to be tough to get a national interest exemption approved. So it's just right now, people just have to be creative if they need to travel to these areas where there's travel bans, or if they're from there. And I know we have a lot of South African Australians. We have a lot of Australians who, you know, have been living in China and some of these places. So that's why I've really sort of talked about this tonight. And so many people that want to go on vacation to Europe. So that's also why I'm bringing it up. People just can't just go to Europe without. And then maybe this will open up, but I don't know. Right now, this is the bans that are in place, and we're seeing more and more countries added. So as of today, May 4th, India got added as a country that you cannot travel to the US directly from. So keep an eye out for that. If it changes over the summer, we will totally love to do an update and give everyone the amazing news, because everyone's going to be getting on airplanes, probably. Okay, next up, green card holders outside the US. We've got so many questions about this again. We went into this in really great detail last time, so I'm not going to go into it in the same detail that I did last time, but I'm going to give an overview. Also because there's been an update since last time, which will make these people feel a lot more comfortable with what I said last time, which was just come, even if it's been more than a year. And I know people were still hesitant. Oh, but. So now the Cbp has issued guidance to the airlines and said, if the person has this, and one of them is, if they have a valid green card, you got to let them on the plane. And Cbp is only telling airlines, let them on the plane if Cbp is thinking, Cbp is Customs and Border Protection, so the immigration officers that are letting you into the country. So Cbp is only saying that if they think they're going to let you into the country, right? So we can get a good idea of who they're letting into the country from this memo, and I'm going to share the contents of that memo, and then we can share a link to the memo for people to have with them.
Okay, I'll do it in chat right now.
Awesome. So I thought we'll cover this with how long people have been, from groups of people and how it applies to them, how long they've been outside the US. So if you've been outside of the US for less than 180 days, you should try and come back before the 180-day mark if US citizenship is important to you, because you'll then just keep coming back every 180 days, because then you'll preserve your ability to file for citizenship without any issues. If it's been more than 6 months, but less than a year, if citizenship is still important to you, still try to come back before you hit the 1 year mark. Because once you hit the 1 year mark, it does make citizenship take a much longer process. And I went into this in depth in the last video, so I'm not going into in depth tonight's webinar, so someone can go back to that. And it does also make it easier when you are coming in. So CBP is saying, we're going to let these people on the plane and we're going to let them in, but they might ask you, if it's been more than a year, they might ask you some questions to check that you didn't intend to abandon your green card while you were away. So if you've been gone more than 365 days, if your green card is still valid, you're going to have no issues boarding the plane, and you should have, but you might get some questions from the CBP officer. So what you want to have with you is some evidence that you didn't intend to abandon your green card. So bring with you evidence that if you maintain property here, that you maintain property, your mortgage, your lease, any bills that you continue to pay. If you still work for a US employer, take evidence of that. Those sorts of things are great evidence that you did not intend to abandon your green card at all. So make questioning very quick and easy. Need to point out though, anyone who, even if you have a green card, because I've got this question a lot, I have a green card, do I still have to apply for the exemption to leave Australia? If you've been in Australia more than 12 months, you're an Australian national, which you are, because a green card holder, you still have your Australian passport, not a US passport until you're a US citizen, then you need to apply for the exemption still to get out of Australia. We had some families try to apply for an exemption and it got denied the first time. They came to us, we helped them get it approved. So if you're applying for the exemption and it doesn't get approved the first time, you can apply multiple times until it gets approved, and it will get approved. They are letting green card holders back out of the US back out of Australia, sorry, to the US. Okay, one thing which I said last time, want to say it again now, is when you come in, immigration officers can sometimes, I think they've been directed now to make people less nervous because of this memo, but sometimes people are made to feel really nervous and like, oh, well, you abandon your green card, you should give it up. Don't ever let the immigration officer force you to give up your green card if you don't want to give it up, because they're not allowed to. You can always say, I want to be seen before an immigration judge. They will let you in and they'll put you in front of an immigration judge. We've never had clients get to that point. Don't ever sign a form I-407 unless you want to give up your green card. Because if you sign that, that's saying you're relinquishing your green card, and that's irrevocable. So just never sign one of those unless you're like, I want to give up my green card. So I'm going into the US a year later so that they can present that to me and so I can sign it. I'm going to ask to sign it, which there are some people that want to give up their green cards, so might apply to them. That's a way to give up your green card. Okay, so this was the contents of the memo, the CBP memo to the airlines, and this will give these green card holders that have been outside of the US for more than a year confidence in coming in. So this was issued on March 5th, and the Customs and Border Protection said, if you have an unexpired valid permanent resident card, if the traveller has an unexpired valid permanent resident card, you can board them without any additional documentation. So if your green card's still valid, you're going to be able to get on that flight. A re-entry permit. So a re-entry permit, a lot of the listeners that were concerned don't have this re-entry permit, because a re-entry permit can only be applied for from within the US. And a lot of the listeners that are concerned left like last March and weren't planning to be gone more than a year. They were planning to be gone a couple of months, and now it's led to more than a year. So they didn't anticipate being gone for a long time to anticipate filing a re-entry permit from within the US. But I bring it up now because it's a great thing to know about. If you know you're going to be absent from the United States for more than 6 months, and definitely if you're going to be absent for more than a year, because you can get a re-entry permit that's valid for 2 years, and it will protect your green card for a trip outside the US for up to 2 years and allow you back in to the US, no question, pretty much no questions asked. So for anyone that's come back now on their green card, but they're like, you know what, I think I'm just still going to take some time to go back to Australia, or I'm going to go spend some time in Barbados because I can still work remote, or I'm going to go spend some time somewhere else because I can work remote. If you know you're going to be gone for a substantial amount of time, when you get back here, apply for this re-entry permit so that you don't have to stress next time coming back, because this document is an explicit way of saying, I don't plan to give up my green card in this next 2-year period. Okay, expired permanent resident card. So if you've got a 10-year green card and it's expired, they're saying to the airline, you still let that person on. And this is because the 10-year green card doesn't mean that your permanent residence expired. They give it a 10-year validity date now because they want people to update their photos, is really the reason. Old green cards never even had an expiry date. Okay, so expired green cards that have, if you have a sticker on it or you have filed an I-90 for an extension of your green card and you got the receipt notice of that, you can come in with that as well. I'm speeding up because I know we're running out of time, Louisa, and I always talk too much. So expired conditional resident. So this is the category that I need people to be, this is the category of the group that could have issues. So conditional residents get a 2-year green card. And the people that get a 2-year green card are people that marry a US citizen and they go to their green card interview. At the time they go to their green card interview, they've been married less than 2 years. Those people are getting a green card that's valid for 2 years. The other people that get a green card that's valid for 2 years are EB5 green card holders that apply for their green card. They get a 2-year green card, but then they need to lift the conditions off. Both groups need to lift the conditions off in the 3 months preceding the expiry of that 2-year card. So as long as you filed, and that filing to lift the conditions is called a 751. As long as you filed a 751 and you have a receipt notice of that filing, you can come in and that 2-year green card's expired, you can come in with the original receipt notice of the 751 filing and the expired green card. If you have been abroad and you're in this category and you did not file your 751 and your card's expired, then it's going to be a little bit more difficult because you can't file a 751 after the expiry if you of that conditional resident card unless you get divorced. Divorce, you're allowed to then file it late. So I don't think we want too many clients like having to get divorced to just get back into the US. But basically, if you're in that group, contact your immigration lawyer to figure out, what you're going to show, how you're going to get back into the US and so forth. Sb1 visas, we covered this in depth last time. Most of the people, I am encouraging people not to try and apply for one of these because it could actually jeopardize your ability to get back into the US. So hopefully, we don't need to worry about that. And go back, if you've seen this in your research, because you're watching tonight and you've been panicked and so you've been Googling and you've been seeing Sb1 visas, definitely watch the last webinar as to why I discourage that route of coming back to the US. You've got a valid, if your green card's valid, just get on the plane. They're going to let you on the plane. And this is indication that CBP is also going to let you in because CBP doesn't let people in unless CBP doesn't tell the airline to let someone on unless they think they're letting them in. And that's why here it says, to the airlines, the airlines should not be determining whether they're outside of the parameters of this. So if you meet the parameters of this, the airline should be letting you on and that's it. If they're not sure, then they're supposed to be contacting this regional carrier liaison group. So that's why I was saying, Louisa, if people want this memo, I think you put the link to it in the chat. They could print this memo to have with them as a security blanket when they're checking in, that if they have a hard time, it's been gone more than a year or your 10-year green card's expired, they can show this memo and like, well, I'm actually can get on the plane. And here it says, if you're not sure, to contact the regional carrier liaison group. So that's what you're supposed to do. It's just gives people confidence and make them less nervous. So that's there in the chat for people. Okay, so hopefully now all our green card holders that have been hesitant and scared and worried about coming back have no fear and they can come back to America. E3s, this is the other big category of questions that we had. What is the situation? How do I get an E3 renewed? Where can I get an interview right now? What's happening with the I-129 with premium processing? All right, so mail-in and interview in Australia is still an option. Interview in a country outside the US is still an option. We're going to talk about how to approach that. And that also applies to the people that need other visas, H's, L's, O's put in their passport and don't want to go back to Australia. So whatever I say under that category applies to those people too. I-129 E3 filing from within the US, just going to give an update on that. I'm not going to go into it in depth because we've gone into it in depth in other webinars. And with the premium processing, I'm just going to give an update. I'm not going to go into if you should, you shouldn't you, because we did that last time, but I'm just going to give an update on what I'm seeing on that and what people should look out for and consider. Okay, so What are we seeing with the mail-in appointments in Australia? What we're seeing is that for visa appointments in Australia, we're seeing really early availability. So in the pandemic, a lot of people say, oh, the appointments aren't until like October or, you know, so many months out. Right now, the earliest available appointments are in May. Right now, we're in May already. So towards the end of the month now, they're available. You need to consider that you can't book an appointment and date until after the 2-week quarantine. And similarly with the mail-in, you need to wait. Mail-in is when you're applying for the same visa category that you have right now, and you mail in your documents and you don't go to a visa appointment. And then they put the visa in your passport and they mail it back. And we went over the mail-in process and whether it's right for people in another webinar too. But we're seeing the mail-in happen in 3 to 10 days. So 3 days was the fastest. 10 days, and the 10-day one was because there were a couple of public holidays either side of when they mailed it in. Okay, what are the pros of an appointment in Australia or the mail-in? Is that you have absolute certainty over how long it's going to take you. So you know that in 3-4 weeks, the whole process is going to be done. There's less risk of an RFE than filing an I-129 if you're thinking of Australia or an I-129. You know, you're going to the appointment. The other pro is you're going to get the visa put in your passport. So you're done at that point until the next 2 years. If you file an I-129, you don't get the visa in your passport. Next time you travel internationally, you're going to need to go through the visa process again. So that's the pros. The cons, flight cost and availability, quarantine. So we're seeing that the cons right now are really outweighing the pros for a lot of the people that come to us. And they really are just like, I just want to avoid Australia at all costs. And so that's fine. And the good thing about that is that there are other options. So the only thing with the other options is you have less certainty on timing. So Australia, the pro over every other option is certainty on timing. You can map out the timing. With the other consulates, you need to try and get an appointment. You don't know when that appointment is necessarily going to be. You can aim for a date, and sometimes it could be quicker than going to Australia. And often, yes, if you can get an emergency appointment, but you're not guaranteed if you're going to get an emergency appointment. So there's just more variables if you're doing it outside of Australia. So how to approach this process of doing it outside of Australia and how we approach it is, someone asked the question, how long before my visa expires should I start the process? And pre-COVID, I would say, oh, a month, 6 weeks is plenty of time. Now I'm saying to people at least 3 months, and 6 months before your visa expires is not too early, especially with securing visa appointments, because some visa appointments are available in 6 months. So you can have that already there for when your visa is expiring. So definitely, even if your visa is expiring in 6 months, now you should be thinking about this. Okay, so first thing you're going to do is find a country that you can enter as an Australian, because a lot of countries you can't enter. What's the quarantine requirements in that country? If you're going somewhere that has a quarantine that's as long as Australia, then what's the point? Ensure you can travel back to the US from that country. So a lot of people are like, I did it in London last time. it was so easy. I'm going to go do it in London again. Well, not so fast unless you're exempt, yada, yada. You're not going to be able to get an appointment there. NIE, that conversation comes up. So just check you can come back from there. Are there regular appointments available in the timeframe you need? And if so, what's the trend been at that consulate? Have they honoured regular appointments? Have they been cancelling the regular appointments? For a long time, when we're seeing consulates cancel regular appointments and only honour emergency appointments. Australia right now is honouring regular appointments, because for a while there, Australia was not, and only honouring emergency appointments. Australia is honouring regular appointments. Okay, what about, will you need an emergency appointment request? And if you do you have a good reason for the emergency appointment? Often you can get an appointment at a consulate that's way out in the future, and then try and request an emergency to try and bring that appointment earlier. The pros is it's closer to the US, no quarantine, for a lot of these places that, we're sending people, there's no quarantine or a shorter quarantine. It's much faster, it's less costly than going back to Australia. The cons, where it can get expensive is often when we're doing it for a client, because they have a short window of time. Usually it's not like they have the luxury of long time. If they have a luxury of long time, then we can just pay one MRV fee and see how that goes. But typically, because we need to get an appointment really quick, we're paying multiple MRV fees and applying at multiple consulates at one time. So if you're trying more than one consulate at once, that MRV fee is only good in the country that you've paid it in. So if you want to try Panama and Guyana and Costa Rica at the same time, you're paying the MRV fee 3 times. It's not going to work with just one across them. So just want to point that out. Risk of the appointment getting cancelled or rescheduled. So we've seen even emergency appointments get rescheduled and or cancelled. So we had clients that went to Bermuda, and this was around Easter time. Bermuda got they had an emergency appointment, and they had an influx of COVID there, and so the consulate shut down. So they said, we need to postpone your appointment for a week. And at the time, Bermuda also required that you were there 8 days before your appointment, and so they had factored in 8 days for their appointment now, and a week for, to do their appointment, get the passport back. So they were anticipating being there 3 weeks. Now they were there 4 weeks. So, you just have to know that it's not going to be definite the way that it has been working all the time, and that you've got to be up for things potentially changing last minute. Another one in Chile, we had an emergency appointment that was for someone in Chile that got cancelled. Fortunately, that person had not left for Chile yet when that happened. So there are limited consular options because they're, accepting their own country nationals over third country nationals first. The whole NIE thing and immigrant visas being prioritized over non-immigrant visas. So, so the big, what I'm sure everyone's eyes are glued to is the bottom of that page, which is where can I get an appointment close to the US right now? And those places are Guyana, Costa Rica, Mexico, Panama, Bahamas, and Bermuda are the places that we're currently being able to get people appointments. There were previous places like Dubai. I haven't tried Dubai again recently, just because we've been able to get closer, and they then had quarantine, and so we stopped trying there. A point on the Guyana one. So with Guyana, we've had E3s and Ls. They were guys that went there, and they sort of said their feedback was probably not a great place for a female to travel to alone. But they were grateful to go there themselves because the process was done in 3 days from when they arrived there and then flew back to the US within 3 days. So that was kind of good. All right, so
I just want to give a quick heads up to our audience. If you can stay on for about another 5 minutes, I think there's still some content worth getting through. I think we've just got 2 slides left, so please stick around.
Yeah, I know there's so much content tonight. Well, every time we do these, I'm like, oh, I've got nothing to talk about. And then
I think we've gotten through a lot of really important stuff, and if people can hang on for another couple of minutes, we will stick around. So please keep going, Chantel. We won't keep people too long, I promise.
So I'm going to just talk about what I've been seeing with I-129s and with and without premium processing. So I think, once premium processing was released in February 27th, so it's only been around 2 months, we saw an upsurge of people try to file an I-129 with premium processing. And often people were like, well, I did my own E3, so I'm going to just file my own I-129. And then, so as a result of that, we've seen a lot of people come to us with an RFE. So I wanted to just give it guidance as to how do you approach this I-129? What do you have to think about other than specialty occupation, which I've gone over and over and over in the previous webinars, but note the difference. For an I-129, it's the employer that is submitting the petition for you. When you do it at a consulate abroad, you're making the application. So the I-129 needs to be completed by your employer, and your employer has to submit it on your behalf, not you submit it on your own behalf. So you should not be signing your own I-129 form. We've seen people just fill out the I-129 form and send that in. That's not going to cut it. You need to file all the supporting documentation with that I-129, not just the LCA. So you need to provide the copies of your academics, your degrees, certificates and transcripts, your credential evaluation, your pay stubs to show that you've been maintaining status in the US. You need to put copies of previous visas in there. You need to put in evidence that the employer is a viable business. So there is a lot more information that you need to be putting in. Make sure you're taking and submitting with that I-129 filing. If you get a lawyer to file on your behalf, they will know that all of this has to go in there. Note also that on an I-129, you do, on the forms, the employer will need to disclose their founding year, their number of employees, and the revenues, the financial figures for the last financial year. Some employers are hesitant to give that to their employee to fill out an I-129, and that's another reason why, you know, having an attorney complete the I-129 process not only increases the chance of that getting approved, but also the chance of your employer agreeing to do it, because they'll provide the information to the attorney that they might not want to provide to you. Okay, pros. You don't have to travel outside the US. Awesome. With premium processing, if you've got a really strong specialty occupation and a good chance of an I-129 getting approved, then you pretty much can time out you have some sort of semblance of how long it's going to take. So 8 days for LCA to get certified from when you start the process. You submit it, 15 days later, feasibly, you could get an approval and start working. So here you are, 3 weeks later, you can work for this new employer, as long as you don't get an RFE. Then extension applications with the same employer, you get 240 days of continued work authorization. So those people don't need to file premium processing because you're already able to keep working, even if as long as you file it before your I-94 expires. If your I-94 is expired, you cannot file it thereafter. Someone asked in the questions, Louisa, they said, in that 240-day period, can I travel internationally? The answer to that is no, you can't. If you're going to travel internationally, you've got to go get the visa, make a visa application to be able to get back in. One update that happened on April 27th, and I snuck it in here, is, and this applies to O's, L's, H's, as well as E3s, but USCIS announced that they're going to go back to the 2004 USCIS guidance that said, if a petition has been filed for this person with the same parties, so same employer, same position, same event, then the USCIS officer can give deference, meaning that the USCIS officer could assume that this petition is approvable as well. So this is huge for people in O1L, H1B that are renewing with the employer in the same category. I don't think many of our listeners and viewers have their previous visa E3 renewal was an I-129, but if it was and it got approved and you're renewing again with the same employer and same position, then this memo will help you. You can pretty much assume that this next petition will get approved too. So people are like, okay, well, I've been approved 1,000 times at the consulate, so why aren't I getting approved now with USCIS, with the USCIS? And the answer to that is that the deference memo does not apply if the decision was made from a different government agency. So when you go to a consulate abroad, that decision is that's Department of State. Now you're filing I-129 with USCIS. So USCIS does not need to follow the decision that the consulate officer made that you qualified for an E3. So that's why you're seeing RFEs if you're filing an I-129 for the first time after you've gotten multiple E3s approved before. And I went into that a little bit in the last webinar too, so people can go back to that in more depth. The cons of filing an I-129 is the risk of an RFE, which can prolong an approval and be difficult to respond to. You don't get the visa in your passport, so you've got to you're doing the visa process twice. If you've got a spouse who's in E3D status and needs an EAD, that's taking a lot longer if you're filing an I-129 and the E3D in the US than if you're consulate abroad, come back and file an EAD. We did get some questions with, what about those E3Ds and EADs? Has premium processing gone into effect for those yet? Because I did on a previous webinar say that it is forthcoming. It has still not come into effect yet, but I can't wait to make that announcement in that webinar because that's going to be a great one, but not yet. It is more expensive to file an I-129 because the fees are more. It's $460, $2,500 if you file in premium processing. Lawyer fees are usually more expensive for an I-129 than a consular processing case because it's more work. And then you're doing the process all over again next time you travel outside the US. Someone did ask, can I just go with my approval notice? And what will happen? Will I get 2 new years on my visa, or will it just go to the end of my visa? You need to make a brand new fresh application when you go to the consulate rather than just the approval notice. Otherwise, if you go with the LCA and the documents that you use to file your I-129, you're only getting until the end of that approval date from that I-129 rather than a fresh 2 years. So you may as well get a fresh 2 years the next time you go outside the country to do your visa to get it in the passport. Okay, what do we see? I think this is the last slide. What are we seeing as an update? Regular cases are also moving much faster. So, you know, last time in March, I think we still had cases pending that were filed in June under regular processing that still hadn't been approved. Those have now been approved. But we're seeing cases now that are filed under regular processing without premium processing getting approved in as little as 6 weeks, even a month, which is crazy. Which could change people's tactic of, oh, I'm going to file it just to buy the 240 days. You might not buy 240 days if it gets adjudicated or an RFE comes sooner or a decision comes sooner. We're seeing a lot of people coming to us with RFEs. What are those RFEs? So this is the point I wanted to make. So we're seeing predominantly RFEs about specialty occupation. I've gone over that 1,000 times. But the other one I'm seeing now are RFEs about the LCA that was filed with the I-129. And this is particularly when people have filed it on their own, because a lawyer knows how to make sure that the LCA, well, actually I've seen even when a lawyer's filed an incorrect LCA. But so you want to make sure the LCA is correct, because if you get an RFE about the LCA not being correct, that can't be fixed in responding to that RFE. The only way you can get over that RFE is if you have a valid LCA the way they wanted it, but it was effective from the time you filed. You can't later file it and submit it, because the documents that you submit have to have been valid from the date of filing. So if your RFE is about an LCA, see a lawyer, because chances are, if you try and file a new LCA and submit that it's not chances are, that just won't get approved. So people need to know that, I think. I think that if you, again, going back to, if you're thinking of filing an I-129 instead of consular processing, I think I really encourage people to talk that through with a lawyer to make sure that it's the right choice for them and what the risks are and so forth in their own situation. Which comes to our disclaimer, which is like, none of this should be taken as legal advice for anyone in particular. Always consult an immigration lawyer before you make decisions and so forth. And we would love to help, you know, anyone that needs our help. And that's pretty much it, Louisa.
Okay, that's great. Sebastiano has just asked, can he access your slides after the presentation? We'll make them available, is that right?
Yeah, we'll make them available, absolutely.
Okay, that's great, as well as the recording. So we are really proud to have presented this immigration update. And if there are further updates, we would love to invite you back. I hope that it's good news. I hope it's great news for all of us.
I think it's only got to get better, right? From
here. Chantel, thank you so much. And thanks to everyone who joined us as well. And thanks for all the great questions. We look forward to seeing you again soon.